Hello and welcome to my YouTube channel where we share safe real estate investment tips, talk about property law and share credible real estate investment opportunities here in Nigeria. Basically, every video on this channel is an asset to real estate investors and property buyers. Finally, on this channel, every subscriber is family, a family of millionaire real estate investors. Welcome.
Hello and welcome to my YouTube channel. My name is Raymond Ijoma and I'm a real estate entrepreneur as well as a property lawyer here in Nigeria. Alright, so today we're going to be having a very sensitive conversation, very controversial one. But of course we have to do it because it's important for our client, it's important for the audience, right? And it's the subject matter of power of attorney. I mean, the power of attorney. And yeah, there are a lot of issues around that document, especially as it relates to using it as a title document, But of course, I'm just going to create a premise for the conversation. But the most important thing that we're trying to do here is to create a solution on how not to get into trouble, or the alternative that we are bringing to the table as it relates to the power of attorney. So whenever you want to buy a land with a power of attorney, you may want to enforce or practice the strategy we are going to share in this particular. That is the idea that's the reason we are bringing this to you. We are aware of the argument, but we're going beyond the argument to find a solution that can work, depending when some of the realistic issues are resolved, especially when government decides to bring a permanent solution to some of the inconsistencies that are existing in the real estate sector. All right, so basically, what is a power of attorney? A power of attorney, I'll just read through some of the things that I have, then I'm going to now focus on what I need to bring your way. Okay, so generally, especially in the East, I remember myself and my colleague traveled into EU to help a client to purchase a property, and so then I discovered that they also use a power of attorney as a title document in the East. All right, and I didn't know. Usually what I knew was it mostly applied to the Eastern states. Most Eastern states use power of attorney as a title document. I'm still yet to find a concrete. No, I've asked these questions and nobody has given me a concrete answer. If I remember somewhat interrogating the CEO of a very big company that we had a conversation with, and I was interrogating him on why they use a power of attorney, and he acknowledged the fact that yes, that's a problem. They've had a conversation up to the Attorney General's office, and it is what it is, and they just have to use what they have to use, So they recognize the issue, but it's sad that nobody has pushed up to get the right thing done. In law, at the law school, because this is law, this is legal, we're taught that a power of attorney is not a title document, that a power of attorney is not a title document. So what is a power of attorney? A power of attorney is a tool of delegation. It's a legal tool of delegation. With a power of attorney, you can legally send someone on an errand to do some things for you. That is generally what a power of attorney is legally designed for. I'm going to read a law authority, a case, 2018 case. I have one of 2020 that also endorses this same principle, but it's not. I needed something very clear that can be understood, that will be easily understood by my audience. So basically, it looks at conveyancing law, power of attorney, whether a power of attorney can confer title on a donee, whether a power of attorney can confer title on the donee. All right, in this case, the appellant relies on Exhibit P1, the power of attorney as the document which vested in her the right of exclusive possession and enjoyment of the disputed property. The argument that she claimed only rent and enjoyment of the property without claiming title cannot hold water, since the prayer for injunction effectively means a prayer for title, notwithstanding that there is no specific prayer for declaration of title. In Ude Anwara, 1993, the Supreme Court, which is the highest court in Nigeria, held that the power of attorney is a mere instrument of delegation, which does not confer, transfer, or limit a charge or alienate title to the donee. It does. Who is a donee? A donor is the person given the power. A donee is the person receiving the power. This authority, the Supreme Court, is saying that a power of attorney does not give or alienate title to the donee. First, the mere possession of a power of attorney does not tantamount to valid title to the land. Let me skip through. However, even the registration of a document does not confer legitimacy or validity to it if it had no power to convey anything ab initio. So even if you register it, it doesn't confer title. It still doesn't confer title. All right. The same case further says that the power of attorney merely warrants and authorizes the donee to do certain acts in the stead of the donor, and so it is not an instrument which confers, transfers, limits, charges, or alienates title to the donee. Rather, it could be a vehicle whereby this act could be done. This act could be done for and in the name of the donee to a third party. I'm going to end there and I'll explain a few things. What I intend doing here is I've established what the authorities are. I've yet to find a strong opinion against this and a strong real reason why it is done the way it is done, especially in some parts of Nigeria. They say it is jurisdictional, but of course, Supreme Court applies to all of Nigeria. It is not a jurisdictional thing for Supreme Court. Supreme Court authorities apply to every and any state in Nigeria. The Land Use Act has general application. Okay, so but we're not into the argument. We are not here to argue with you or those who use it. What we are saying here is, if I'm the owner of a land and you listening to me, I delegate you to sell. With that power of attorney, you can sell for me. But it doesn't become a title document for you and making the land yours. That is what we are saying. That is what these authorities are saying. However, there's a recent opinion by a judge that the power of attorney the donee can extend or alienate to other people, including himself. Must alienate to other people, including himself. That is still an opinion by a judge. But the concrete thing I need you to do and suggest to you is that whilst relying, if you are going to rely on a power of attorney as a title document, from whichever state that you are from, I would strongly advise that you corroborate such power of attorney with a deed. Yes, do what they need to do. For all the transactions I've done in the East, I have always corroborated it with a deed. By doing so, you place yourself in between. You don't go to this side of the argument and make a joke of or take lightly your real estate investment, or you go to this side and ignoring certain things, certain realities, but you come in between, such that you play this game and you play this other game. All right. So when they say you should provide, what you should provide is a power of attorney, you have it. If they say what you should provide is a deed, which ordinarily should, because in 20 years' time this may change, but what happens to all of those that have power of attorneys as title documents, exclusively as title documents? What happens to them, right? So what I do is I try to play safe, and by playing safe, I do both. All right. So I would suggest our suggestion is that peradventure you have that transaction is going on down there, that only a power of attorney is presented as the title document without even establishing the root of title. Sorry. So basically what I need you to take here is take an important lesson from what I shared about the most important legal principle that applies to all real estate transactions. Ensure that the reciter is tight enough, and find out why a power of attorney is being used. Then the person selling, the donee, if there is no other document explaining or corroborating title with respect to his ownership, then that may even be an issue. But beyond that, if you have to scale through this transaction, then you may want to come in between by using a deed of transfer, a deed of assignment, depending on, and a power of attorney. So that way you are in between the whole transaction. It is an opinion that we hope that you will take seriously, because it has the capacity to prevent you some issues so many years to come. All right, so this is brought to you by Fortreal Rei Ltd, a real estate company registered here in Nigeria, and we help clients to acquire properties, sell properties, carry out consultancy stroke advisory services, and generally help clients to get the job done as it relates to whenever it concerns, or as it concerns real estate investment or real estate here in Nigeria. Again, my name is Raymond German. I'm a real estate entrepreneur as well as a property lawyer. If you have any need at any point, be to reach out to the numbers shown right on your screen. Be to like this video, subscribe if you haven't, turn on notification, and stay in touch. Please do enjoy the rest of your day. Bye bye.